All rise. Court of Appeals, Division 1 is now in session.
Good morning. Please be seated. This is the time set for oral argument in the case of LAUFER versus AUDITORE and LAUFER versus Star Indemnity and Liability Company. Our civil case numbers 16-0288 and 16-0463. Each side will have 20 minutes within which to submit or to present their arguments here this morning. Appellant may reserve some portion of that for rebuttal, but it's up to you to keep track of your time in that regard. We have read the briefs, been through the record. We're familiar with the facts and the issues that you bring here today, so please keep that in mind as you make your arguments here this morning. We are recording this argument both in terms of audio and video. So, and in fact, the video portion of this will be available on YouTube in a matter of days in case you want to go back and relive the glory of today. In any event, as you approach the podium, we'd appreciate it if you would identify yourself and your clients for us as you start. Thank you. And with that, appellant may proceed.
Good morning, Your Honor and Counsel. Charles Onofre on behalf of the appellants, the plaintiffs in this case. With the court's permission, I'll address first the duty issue with respect to Agent Auditory. Clearly, the trial court was conflicted on this issue. Judge Oberbillig ruled initially in favor of us, only to change his mind. And I think when you review the transcript, you see that he thought it was not his place to what he thought might be creating law, and that's best left to this court. Here's our simple point. The Napier case does not foreclose extending the duty. They had the opportunity to, they didn't. They left the door open. Finding a duty, in this case, encourages the public policy of holding an agent responsible for the negligence. And it does not create this unmanageable set of duties that they argue. There's one duty. It's the duty that's owed initially to the named insured. And as long as they discharge that responsibility, that's all that's being asked of them. So there isn't this parade of terribles that they've been concerned about. In Napier, of course, the difficulty of applying that is that involved an unknown and unknowable claimant. There was no relationship that existed with the agent. And obviously the court was concerned about a public policy that exposed an agent to a duty to, I think their words were, literally everyone in the state. I would point out that in Napier, they had I'll call it the escape valve. The plaintiff didn't go uncompensated. Plaintiff could sue the owner of the cab company for not doing what they were supposed to do. And while it wasn't presented, that owner obviously has a claim against the agent. That's a distinguishing fact I probably didn't focus in on, but it is a difference.
So, but under this theory, though, the argument would be that the insurance agent for the company owes a duty to every employee, in this case, who drives a car, so every employee of the company?
Well, certainly. I mean, we're here advocating on behalf of Jack LAUFER, and I think the Napier court had the best quote that would discuss really what we're talking about. They say in there, the professional's duties to the client are discharged for the benefit of the non-client. That's because with UM and UIM, the named insured makes the decision about what to get, when to get, and they bind everybody. We're simply saying the named insured has to be in a position to do that in order for the rank and file to protect themselves. This UM-UIM was not for spray foam, certainly.
So every employee of a company like that would be able to sue and recover against the agent?
I suppose depending on the theory, and maybe this is why what we think is a mischaracterization of our claim, the defense repeatedly does that. Our claim is very fundamental. Mr. Auditory had an obligation to simply know the product that he was selling, knowing that he was taking to the named insured an excess policy that did not provide the coverage that he believed and Mr. Radabanko believed existed. Simply put, there's 6 different coverages under the business auto policy. Here's an excess policy that only covers one of them. All we're saying is all he has to do, know enough to explain that to the named insured. Then the named insured can make a decision, and presumably they inform the rank and file.
In this case, though, how do you get past the evidence on causation, which is that the named insured would have said, no thanks? I mean, that's what he says under oath.
Well, yes and no, and this gets into a lot of details. First, to point out the court didn't rule on that basis. The court found a fact question on the causation. You have to realize that we have this affidavit signed by Mr. Radabanko, and the affidavit quite clearly provides really the evidence that we need on causation. Unfortunately, there was a suit brought against the agent a week after the affidavit is signed, who is his friend. And quite frankly, I think, at least in front of a jury, they would see that there was a change in view about the position they wanted to take. There's no doubting that Mr. Radabanko thought he had coverage. That's in his affidavit.
But that's because that's not based on any promises or discussion about it. He just assumed that he did.
Well,
the company did.
That's certainly what he testified to. He also testified to the fact that when he found out there was no coverage, I think the quote was, "What do you mean there's no coverage?" And when the renewal came up, he asked the agent, "Can we get it?" We look at that and say that's evidence that he did want it, and he would have gone after it. There's also evidence that we didn't focus in on, but they spend $1 million a year in insurance. They were going to double the excess coverage a month after this placement. And so the suggestion that he wasn't going to go get it, again, is maybe is a reformed version after realizing that that affidavit was going to be used against his friend, Mr. Auditory.
Is there a case for the proposition that on summary judgment the court can assume that that a deponent didn't testify accurately? I didn't ask that question the right way.
Well,
but how can the trial court or we on de novo review assume that a jury might disbelieve that testimony, which is what I think your case needs to hinge on?
Well, in part it does, but you have to bear in mind we have an affidavit from him. That's what's signed initially. This is not an instance where testimony is provided, then the affidavit comes up to contradict it.
But the affidavit says I was surprised. I don't think the affidavit says I would have bought the coverage had I been told about it.
Well, but in his deposition testimony, we also have him saying, when I found out it wasn't there, I asked the agent, can we get it? The clear inference is if he had been told about it at the time, he would have asked the agent the very same thing. Can we get it? I think that inference is obvious, the fact that once he realized it wasn't there, can we go get it? I don't know what else we would point to. Granted, he does contradict that in talking about, well, that wasn't the overall intent initially of getting the coverage, but nonetheless, he said that, and frankly, in front of a jury, am I going to be impeaching him to a certain extent? Yeah, I am. And is that out of the ordinary? Yeah, it is. This case is out of the ordinary because as soon as he saw that affidavit as being used against his daily drinking buddy, the tune changed. And that's just something that's going to have to be meted out in front of the jury, quite frankly. It's a fact question. In any event, so we think when it comes to the duty, it's either based on public policy or the relationship. From our perspective, Jack Laufer comes as close to being a client as a non-client can be. We're talking about the placement of UM that's not for spray foam. It's for the individuals. We know that the named insured binds them. He's a part owner, closely held corporation. signed vehicle, uses it 24/7. So again, as close as you can be to being a client without technically being a client. And I might even point out that Judge Oberbillig, at page 63, the transcript says, I don't know if he's a non-client. It was a really close call for Judge Oberbillig. So we think the relationship is there. In terms of public policy, obviously we don't want to give the agent carte blanche to commit malpractice. The overriding concern, and quite frankly the one that I think swayed Judge Oberbillig, if you look at pages 71 and 72 of that hearing transcript, I think he accepted the argument by the defense that look at what the agent is going to have to do. He's going to have to know who all the employees are. He's going to have to track them down, talk to them, know their financial status. That's why they want to characterize our claim as failing to recommend more UMUIM. It's not our claim. He simply has to know what he's doing. I am giving you or getting you an excess policy, and just so you know, even though it says you're going to follow the underlying policy, it actually is providing you one of 6 coverages. That's the only obligation that we're asking him to discharge. That doesn't create any additional duty at all. The named insured, obviously, Mr. Radabenko thought there was coverage. He wasn't told otherwise. And Mr. LAUFER cannot protect himself, and hence there's some reliance because he doesn't know any more than Mr. Radabenko or Spray Foam knows. He can only protect himself if he knows the excess policy does not apply. So again, we think an important fact is not to buy into the mischaracterization by the defense of what we're claiming. 8 times in their brief, they say our claim is failing to recommend additional coverage. No. Our claim is know what you're selling, discharge your responsibility to the named insured who makes the decisions, and then people can then protect themselves accordingly. If the named insured is advised, this doesn't provide the coverage. We think that's enough of a relationship that creates a duty, and there's no countervailing public policy that expands the agent's duties.
So the duty, as alleged, is to explain to Radabenko that it's a follow form policy with certain exceptions, and here are the exceptions.
It doesn't even have to be that complicated. It's saying this is an excess policy that covers only third-party liability, period. That's all he has to say. That's not asking a lot from a licensed professional. That's just knowing what it is that the product that you have. Again, we think that would be within the realm of reasonable care of a licensed professional. On the STAR issue, I think I can be very brief on this. We claim that the binder, by virtue of the follow form promise, either created a contract because by using those words, that underlying policy came into existence. It was already issued. They're saying that's part of the policy, and then they issue another part for the liability. Or it created reasonable expectations. You said you were going to follow the underlying policy, and you issued something that didn't. The court found a fact question on both of those. The court initially granted our motion to dismiss the exhaustion defense. Court, when you read the transcript, he doesn't have any problem dismissing that. They filed the motion for reconsideration, and then he reverses his decision again on this issue, and he grants it as to both. The exhaustion defense defeats both of those claims. Here's our point, and it's very, very simple. If you believe our version of the binder, and Judge Oberbillig said there's a fact question, then what that means is you look at the underlying Diamond State policy. You do not look to the third-party policy that STAR issued, because, as Judge Oberbillig ruled, that says nothing about UMUIM coverage. So if you agree with our interpretation, ladies and gentlemen of the jury, they promised to follow the terms, conditions, and coverages of the underlying business auto policy. That includes UMUIM, and more specifically, the UMUIM endorsement to the Diamond State policy provides for an offset, not this exhaustion requirement that is in the third-party liability policy.
But doesn't the binder expressly note that in the event of any inconsistency between the binder and the policy, that the policy language controls. And the binder, as I read it, although it identifies excess UM and UIM as a potential coverage, it expressly notes there's no premium charged for that component of the policy.
Glad you pointed that out, Your Honor. What you're looking at is the star binder. The RT binder removed that language, the premium reference. If you compare the two, the premium reference to earned, unearned, and then UM/UIM, that's on the star binder. RT removed that language.
Well, did they remove the language about inconsistency between the binder and
No.
the policy?
No, they didn't, Your Honor. And here's,
Isn't that the critical language?
well, I think the critical language is,
I mean, doesn't that really defeat this whole reasonable expectations argument?
not when you read paragraph 3, Judge. When you read that, and if you keep in mind on page 3, which is the most, that's a narrative description, all right? It's not one line, it's a narrative description. It has the magic words, "it is intended." If you keep in mind the difference between policy and coverage and exclusion and endorsement, what that says, we're going to follow the underlying policy unless there's an endorsement that says we're not. That's what those words say. And I'll point out that what the opposition relies on primarily is on the first page where it says coverage, excess liability. That same broker issues a binder, and this is in the record, for auto liability, and it includes UM/UIM. This broker does not use the word liability to mean third-party liability only. They don't. If you look at that binder that is issued before the loss is incurred, it looks very similar to this one, but it's July of 2012, right before the loss, and it's for auto liability. It quite clearly includes UM/UIM coverage, and that is Exhibit D to the response on April 5, 2012, the record at 121.
Now,
And-
I'm looking at Record 64, which is one of the parts of the attachments to the summary judgment briefing. Exhibit Y, which is the copy of the binder emailed on January 31. You're saying that that's not, Exhibit Y is not the copy of the binder that went to spray form?
The binder that goes to Mike Auditory, the agent, is the RT binder. It is not the star binder.
What goes to spray foam?
I don't think the record is clear whether, in fact, it actually was sent. It may, I think the testimony was, it is typically or occasionally sent, but I don't believe that Mr. Radabanko could say that he, in fact, received that specific binder, but he has received binders in the past.
So the record's not even clear that he received a binder of the excess coverage?
That is correct, but it's clear that the agent did. And from our perspective, the representation to the agent is a representation to the insured, because, again, we have testimony from the agent. If I knew otherwise, if I knew this wasn't covered, I passed that along to the agent.
Okay, so say it again. Exhibit Y went to RT, but we don't know whether it went to Auditory?
If Exhibit Y is the star binder,
Well,
it would stay, it's right on the heading, right at the top.
star binder, it says star on top.
Right. Star binder goes to RT. RT takes that binder, includes most everything, sends it on to Auditory. It removes the UM/UIM premium reference, and I think it takes out the commission.
And so where's that exhibit to be found? Is that the Exhibit D to the response, Record 121?
It should be part of that same statement of facts. I don't have the exhibit number reference, but it's the December 7, 2015 statement of facts, Record 61 to 64. And the binder that was on the motion for reconsideration is the later binder issued by RT, where they called auto liability coverage, auto liability. You know what it's covering? Liability, UM. They do not use the word liability to mean third-party liability only. In the record, there's an exchange of communications between RT and Mr. Auditory. After all this is figured out that there's no coverage, RT is telling Mr. Auditory there's no coverage, not because it's not covered, because there's an exclusion. That shows you they don't know that the difference between an insuring agreement, if you're going to rely on exclusion, then you think it's all initially covered, but there's an exclusion. They do not use the word liability to mean third-party liability. I think that much is very, very clear. And again, if you read that page 3, keep in mind the difference. Policy, coverage. Those words are not interchangeable. They mean different things. If you read page 3 and you put in the word coverage versus policy, you'll read it a lot differently. In fact, if you read that, if you compare that with what they are really saying, which is, you know that business auto policy? We're going to follow one of the 6 coverages, not everything, one of the 6. That's what they're saying, or say that they said. Take that and compare it with what's written there. That binder does not convey that impression. Thank you.
Thank you, Your Honors. May it please the Court, my name is Deborah Verdier, and I represent the defendants' appellees in this case, Michael Auditory and Auditory and Associates. Because the issues as they relate to the insurance agent's duty to non-clients are fairly straightforward, I am going to strive to keep my time to as close to 5 minutes as possible, reserving the balance of the time for my co-defendant, Mr. Leonard. In Arizona, the general rule, as it relates to a professional malpractice claim, is that there must first be a duty. I'm a lawyer. When somebody hires me and engages my services, I owe them a duty. What I'm not hearing in the appellant's argument is that first premise. The argument that he made to you and in page 2 of his reply brief was that Mr. Auditory failed in his duty to explain to Spray Foam this policy. That ignores the fact that Spray Foam is not here in this case. Spray Foam is not a party to this case. The premise in Arizona is that a professional does not owe a duty to a non-client. There is case law from this court and from the Arizona Supreme Court that addresses the scope of a professional insurance agent's duty to a non-client in the specific context of the case of the UM-UIM coverage. The Napier case that was referenced by appellant's counsel is distinguishable. It's distinguishable in 2 ways. One is that Mr. Auditory happens to know the plaintiff in this case. The second way is that in that case, the UM-UIM coverage that the insurance agent neglected to get was mandatory insurance. In this case, the insurance, Mr. Auditory did procure $1 million of UIM coverage for Spray Foam, and we are talking discretionary excess insurance. Now, looking at the history of Arizona case law on insurance agents' duty of care, supports the trial court's ruling in favor of Mr. Auditory. First came the Darner case. The Darner case was not a non-client case, but what Darner had to answer was, is an insurance agent a professional such that he owes his duty to his insureds, his clients? And they answered that question in the affirmative, and then there was some significant discussion about the scope of that duty. Next, in 1991, this court in Ferguson had to answer the issue of whether or not the insurance agent then owes a duty to a non-client. They started again with the premise that the general rule is that an insurance agent does not owe a duty to a non-client. The plaintiff in Ferguson was a student at a boarding school who was injured at the school, and the school's primary policy was inadequate to cover the judgment for the student's injuries. The student's family sued the agent for failing to procure adequate insurance for the school. Again, after starting with the premise that there is no duty owed to non-clients, the Court of Appeals examined whether or not there were any special circumstances, sometimes referred to in the case law as special relationship, sometimes special circumstances. After examining it, the court concluded that the agent owes no duty to a third party to recommend insurance to the insured in a particular amount where no insurance is required by law. Again, this gets us into the context of an umbrella policy that would be additional discretionary insurance. Then in 1998, the court revisited the issue of an insurance agent's duty to non-clients in the Napier case, which has been discussed, so I won't get into it too much more other than to say that despite the fact that the insurance that the agent neglected to procure in that case was mandatory insurance that was requested by the client. That is not the case here. Mr. Radabanko testified that he never requested an umbrella policy that would cover UIM coverage. Now, I would like to address briefly the issue of the Radabanko affidavit. While I don't think that it's necessary for the court to analyze the facts to that level to come to the same conclusion as the trial court, but I will tell you that operating under the assumption that Mr. Radabanko, who is not a party to this lawsuit, would perjure himself to help a friend who he has a personal relationship with and a professional relationship with, to the detriment of the family of a man who he worked with for 30 years. There is simply no motivation for Mr. Radabanko to commit perjury in this case, and that is a red herring that should be disregarded.
Is there any evidence that a company in the position of spray foam could have purchased excess coverage for uninsured, motorists at that time in Arizona, given that the law did not require it to be offered?
Well, thank you, Your Honor, for that question, because it actually ties to something that Mr. Onofre said, which is that Mr. Radabanko testified that he asked, can we get it? What he neglected to tell the court was that the answer was no. It would be cost prohibitive. There is some evidence by our expert in the case that the coverage would not be available, which then goes to causation. There is no $5 million UIM coverage available on a commercial auto policy of this type in Arizona.
Where do we look in the record for the proposition that would have been too expensive?
That would have been in our expert report, of the expert report of Neil Bordenave. And I would actually direct the court to the lack of evidence that there would be availability of that. Plaintiffs who have the burden of proof in this case disclosed no quote from another carrier that had said this coverage would have been available and it would have been worth, it would have cost a premium of X dollars. There's simply no evidence. So I don't think that the court actually needs to get to the defense experts' opinions in that regard because of the lack of evidence from the plaintiffs on that regard. So I would like to talk briefly about the concept of the public policy arguments that were made. Our arguments to the trial court were frequently mischaracterized by the appellant's counsel. The reason we were arguing about what would Mr. Auditore have to do to satisfy his obligations in this case, we were making those arguments in the context of there is a public policy position. If the court is going to expand existing case law on the issue of a duty of an insurance agent, it needs to look at the competing policy interests. Mr. Onofre stated the one policy interest, which is you need to be able to hold insurance agents accountable for their negligence. The competing policy interest is you necessarily have to look at what would this mean for insurance agents going forward who are selling commercial auto policies to companies that have multiple drivers. And I see no distinction between Mr. LAUFER versus the other 45 spray foam drivers. And so that is the basis for our making those arguments. We aren't mixing foreseeability and duty in doing that. We're providing the court with a public policy argument for why that happened. And if I could briefly also remind the court that in 2014, in the KB Homes case, the issue of an insurance agent's duty to a non-client was again revisited. In that case, the agent in KB Homes was asked to provide a certificate of insurance to an additional insured who was not his client. He specifically did that a certificate of insurance personally. There was direct contact with the plaintiff in that case. After it came down that the additional insurance did not qualify, or that person did not qualify for additional insurance as an additional insured, they sued, and the court concluded that that transaction, that direct contact between the insurance agent and the plaintiff, was not enough to create a duty because that plaintiff was not a client. Spray foam roofing was Mr. Auditore's client. Mr. Laufer was never Mr. Auditore's client. The cases in Arizona on this issue support the trial court's conclusion that Mr. Auditore did not owe a duty of care to Mr. Laufer, and therefore the professional malpractice claims brought by the Laufers against Mr. Auditore were properly dismissed. I would like to yield the rest of my time for my co-defendant if there are no questions.
Thank you.
Thank you.
Morning. May it please the court, my name is Shanks Lenhart, and I'm an attorney for the appellee Star Indemnity and Liability Company. What you've heard so far today from both sides is a description of the appellant attempting to seek coverage that is not available in the market. So this isn't coverage that spray foam, as the court has identified, this isn't a coverage that spray foam asked for. This isn't a coverage that spray foam paid a premium for. This isn't a coverage that you can even get in the market. In fact, the record is undisputed that Star doesn't offer this coverage at any price. And despite that fact, the appellants are asking a court to judicially reform an excess liability policy issued to a roofing subcontractor to create that coverage, a coverage that you cannot buy in the market. This isn't a personal alliance policy. Those policies existed in this case, and they've collected under those policies. One of the issues that Mr. Onofre raised was allowing Mr. Laufer to protect his own interests. He did. He chose to buy $100,000 in UIM coverage for his personal vehicles. That's what he chose to do, and he recovered that. What we're here in this case about is attempt to judicially reform a policy to create coverage that just doesn't exist. Now, there's been a little bit of a straying from what the actual issue in this case is, in my opinion. This is a contractual interpretation case. And in a contractual interpretation case, you've got to start with the four corners of the contract. Well, what is the contract? The contract is the excess policy that my client issued to spray foam. And that's attached as Exhibit 1 to Index of Record 47. We've reproduced relevant parts in our answering brief, including at page 7. That's the insuring agreement right there. That says what's going to be provided under the policy. And it says that we, meaning Star, is going to pay on behalf of the insured amounts the insured becomes legally obligated to pay for loss or damage to which this insurance applies. That's third-party liability coverage.
What about the argument that the binder created a contract and that the warning about endorsements below didn't include this because it's the reference to the excess policies by policy form, not to any particular endorsement?
Well, I'll answer both, but there's kind of two issues there. I'll answer both of them. First, whether or not the binder is a contract is an issue that is, in my opinion, not an issue, because there's a statute that says a binder is not a valid contract of insurance. It's void once the policy is entered. So,
although it may have established expectations.
Sure, it might be evidence of reasonable expectations, but if we're talking about reasonable expectations, then we're talking about you or the trial judge reforming a contract to create coverage where it's expressly not there. So the binder can't be a separate contract. Now, the issue of whether it created reasonable expectations is one that we indicate there's no evidence of. No, as the court pointed out, the insured in this case, Mr. Radabanko, never saw the binder. He doesn't know what the word follow form means. And we've identified a number of areas on that binder, including the one that Judge Winthrop cited, that indicate very clearly what is going to be covered and not covered by this policy. For instance, it indicates the first underlying insurance carrier as indicated above. That indicates liability coverages. The appellant's counsel indicates that's our only argument. It isn't. That's one area. And we've laid out the schedule of insurance that shows that. But Additionally, you've got the key clause of that phrase in the binder, which states, and I'll read this directly from the binder, except for those endorsements listed below. And then you list below there a number of things that limit coverage. Even below that particular paragraph, it says limitations. Please note the policy is amended by the endorsements listed below. It's telling you that the coverage is going to be limited by these things. And then you've got the terms and conditions that the court has already identified that indicate in the event of any inconsistency, the policy is going to control.
What about the reference to endorsements? And what we have here is not an endorsement, but a term within a standalone policy form.
Well, Your Honor, there's been no testimony in this case from Mr. Auditore or Mr. Radovenko that they read this binder and misunderstood that when it said endorsements that it was going to be something different than what was listed here. Mr. Auditore has testified when presented with this document, is there anything in this document that indicated to you at any point in time that the carrier was going to be providing you with uninsured motorist coverage? And he said no. So we can have an academic argument about the meaning of endorsements versus policies, but unless there's evidence in the record that somebody was misled by it.
Well, but the evidence is that Radovenko thought it was a follow form policy. He might not have understood the term, but he understood that concept, and the rebuttal of that is, well, not really, because the binder says not always follow form. Well, so you can't rely on the binder's language for some purposes and not for others.
Well, again, I think we're straying outside of the record. Mr. Radovenko, as the testimony indicated, never saw the binder. What he had a general, as you, I think, fairly described it as just a general assumption that he had coverage for something. But if you're going to talk about reasonable expectations, it's got to be objectively reasonable. And when I went through his deposition, and I've excerpted that in our brief, and I said, what was that expectation based on? Was it based on a statement? Was it based on a document? Was it based on the fact that you had another claim that was covered? Each time, no, no, no. And then I asked him specifically, did you have a specific expectation that you had underinsured motorist coverage, as opposed to just that you were covered for everything? And he said, no, I didn't have a specific expectation of that. And I would echo the same comments that Ms. Verdier made about this purported conflict with the affidavit. So you have to really look at what the record is before we determine whether or not there's reasonable expectations. But let's assume for the purposes of the argument that there is some dispute of fact on reasonable expectations. We disagree with that, and we've cited the record. It doesn't cure the issue with the exhaustion clause. That's condition M.
Before you move off the binder, do you have a record site for the copy of the binder that went to that
I
RC
do. It's
sent
Exhibit
to,
AA to the same statement of facts.
So RA-64 or a subsequent Exhibit AA?
Double A, yeah.
Actually, it's probably the same document.
Yeah.
Okay. Thank you.
So on the issue of exhaustion, there's really only two outcomes here. One is there's no evidence of reasonable expectations, and we know the excess policy doesn't provide coverage by its express terms, so there's no coverage. The second option is, well, we're going to find some question of fact on reasonable expectations. But even under that outcome, it doesn't satisfy condition M, which is what requires exhaustion. And there's very specific language in that condition that requires exhaustion by actual payment of the full policy limit. And that does not limit that condition in any way. It says coverage under this policy. So if you're going to reform the policy to include UIM coverage, despite the fact that it says it's third party only, and despite the fact that there's a specific endorsement, or excuse me, an exclusion that says we're not going to incorporate in first party auto coverage. If you're going to reform that, it's still going to be subject to the condition that indicates coverage on this policy will not apply unless it is paid in full. That particular provision has been considered in a number of courts throughout the country, not in Arizona, and in each indication it has been enforceable as a condition precedent for coverage.
What's the case you can cite to us that used this language, interpreted this form language? Because we couldn't find it.
The identical language of the STAR policy is in the Intel case, which is a Supreme Court case out of Delaware. That's the one that says either the insured or the insurer must pay full policy limits. The other cases, Comerica, Qualcomm, Citigroup, those are cases where I believe they just say the insurer must pay full policy limits.
has paid or is obligated to pay the full amount.
Legally obligated to pay, correct, Your Honor.
Well, this doesn't say legally, just says obligated.
Fair enough. So under the language, again, our position is that if you look at Comerica, Qualcomm, Citigroup, and Intel, those are the 4 primary cases that we've cited for this proposition. The language of those policies is materially identical to ours. That's our position. They all require actual payment. And in fact, many of the arguments that you would hear from appellants on why that isn't a good rule to follow have been rejected in each of those cases. For instance, the arguments about, well, by giving an offset or credit, doesn't that still just expose the insured to the same limit that they have? Those are all been rejected, and they've been rejected for the simple purposes of you have to enforce the language as it's written in the contract. That segues into our citation of the 1800 Ocotillo case. And so you've got plain language that says it's got to be done by actual payment. That wasn't done here. It's undisputed. And so if you're going to find that that clause is not enforceable, you're going to have to rewrite it to remove that term payment. And whether you say offset or credit or whether you remove it totally, you're going to have to remove it, and you're going to have to remove it based on public policy, and it doesn't exist. There isn't legislative public policy to do it, and there isn't common law public policy. In fact, to the contrary, we've cited the Gilmore case, which is an Arizona Supreme Court case, another Court of Appeals case here, which says that these kind of clauses are a natural part of excess insurance because excess insurance they take a lesser premium for a guarantee they're not going to be paid above that. So unless the court has any other questions, that's all I had. I will mention just briefly with my remaining time on the issue, there was an issue raised on attorney's fees. Our position is that that's an abuse of discretion standard, and no evidence is presented to establish that the trial judge abused his discretion. Thank you.
Thank you. Mr. Onofre, you actually had 18 seconds left on the clock when you sat down. I don't know if you wish to use that or not.
Or even a minute, say?
Yeah, we'll give you at least 30 seconds. How's that?
First, Your Honor, the arguments about causation and whether or not there's an available policy, that wasn't an issue that the court ruled on. It wasn't an issue that was raised in the briefs. To show you how disingenuous the testimony is, Mr. Radobanco said Auditory told him it was not available. I asked Auditory, did you look for it? He said no. That's what's going on here. And if there's any question about maybe they did have a discussion, just take a look at Exhibit I, which are all the applications that were submitted that they're supposed to sign. And right above the signature is a provision for excess UMUIM. How does the topic never, ever, ever come up? It comes up. They just don't want to own up to lay it at the feet of Mr. Auditory. Thank you.
Thank you, counsel. We appreciate the arguments here this morning and the briefing that was submitted in this case as well. We'll take this case under advisement and issue a written decision in due course. With that, we are adjourned.